Just confirming, still audible, right?
Yes, audible, audible.
Okay. Yes. Okay, so we can start. You
Yeah, it
can.
is going on YouTube Live. Just a minute.
Yes.
So, good evening, everyone. Welcome you all for our second Children's Day Awareness Parental Alienation webinar. So, today we have two very special guests. They're very special for me because uh, their thoughts, their perspective was like kind of overwhelming uh, for my intellect because the way they think, way they perceive, and way they dissect the content. I'm sure this is going to be a lot of legality for anyone who's willing to uh, who's expecting to interact and who wants some clarification in the custody laws. And when I spoke with Dr. Mr. Vedant about these things, he really told there's something called as child independent lawyer. So, anyways, I'm just going to the direct program now. And today we have the speaker, esteemed speaker, Advocate Sarvesh Naik. He's a law graduate from Government Law College, Mumbai, a legal consultant, and he's a triple gold medalist, hat trick medalist, and the recipient of the prestigious Justice MC Chakla Award. He is more into social legal issues. He's an aspiring reformer. He wants more solution-oriented reforms. He co-founded with Mr. Vedant, Advocate Vedant, Bharatiya Samvidhan Samaj, and is an initiative promoting constitutional and legal awareness. And they frequently give talks about RTIs, the disability rights, democracy, and civic responsibilities. And he is also a proud recipient of Dada Gulbakshani Award for the social work. And it's going to be a great thing. And he's going to talk on the child custody laws, the what are the lacunae in that, and how to go forward. And Lokesh Sarvesh, like the please take over, please. Please proceed.
Sure, sir.
First, we only
Just
hear from you, then we'll be asking for Q&As.
sure. Just confirming. Am I audible clearly?
Very clear. Fine.
Thank you very much. So, good evening, everyone. First of all, extremely grateful for awarding me this platform to speak and to share my views on this very essential and pressing topic. I'm told that the actual session on parental alienation as a concept will be taken on later. So, my duty here, and of course, Vedant's duty here, is to set a stage for let people understand first what are different child custodies law and how altogether the law itself creates and leads us to a situation where the concept of parental alienation arises, and then how we can think of tools and devices to deal with the same situation. To start with, I would like to highlight here a point that when we talk about child custody laws, that phrase itself implies that we have traveled a lot and we have traveled a long path because laws were not to control child custody ever. And if I go into a basic jurisprudence, a law evolves due to the social needs. Law usually takes itself out of different social problems or social issues until it is called for. Matrimonial or patrimonial issues such as marriage, divorce, property, succession, these were the very these were some of the problems which the law touched upon quite late as compared to other things such as crimes, civil matters such as uh, property transfer between person and person, etc., contracts, commercial relations. These were the former things. Now, even in the latter things, which is marriage, divorce, guardianship, succession, children come very late. Firstly, the civil law, the portion which we call as civil law or the matrimonial law or the patrimonial law, it usually attempts, or rather, I would say, distance itself from dealing with children or sensitive matter, and it firstly attempts only to deal with adults. It lays down what are the rights of adults between themselves, or a dying adult to a living adult, like we call succession by will or succession by law. The point of children come very late, and therefore the law has is still evolving in this field. Let's take an example of contracts. So in contracts, the codified law says that contracts entered into by children are void. So it doesn't recognize a contract. It doesn't recognize a situation where even a child may require to enter into a contract for his own well-being. And then we have court stepping in, then the jurisprudence evolving, and now the situation is that even though contracts entered into by minor or children are void, contracts may be entered into on behalf of a minor by their guardian. I'm just giving an example to set a stage that how law always takes time to evolve, and the primary approach of the law is to stay away from human relations and don't enter them unless it becomes inevitable. Now, from this journey, it traveled to the problem or traveled to the situation of custody through the laws dealing with marriage, divorce, guardianship, and adoption, because these were the scenarios which actually made the laws, and then the law enforcements, and then the law adjudicators, that is the executive and then the judiciary, to actually think about what can be the situations and how a third party can get affected when a dispute is there or when an issue is there between two adults whose rights are well taken care of by the law. For example, in India, the child custody laws are embodied in, for Hindus, it is embodied in firstly in section 26 of the Hindu Marriage Act, then it is embodied in section 6 onwards of the Hindu Minority and Guardianship Act. Then for secular, then for everybody, it's embodied in Guardianship and Wards Act, although it doesn't expressly recognize the concept of custody. Then you have criminal laws, which again talk about kidnapping, and kidnapping says taking a minor out of the lawful custody of his guardian or parents. So, in short, the law very indirectly touches upon the concept of custody while talking about something else. And it was very late when the laws such as Hindu Minority and Guardianship Act came, which talk about custody from an active voice perspective, that is laying down the principles that who shall have the custody of the child, when shall have the custody of child, and how shall have the custody of child. Now, this keeping this evolution in mind, one thing's become very clear, that since it is in the evolving stage, the legislature is not the holistic measure of how laws are affecting the society, and it takes us that what role the courts can play. So for that, let us I would like to throw some light on child custody laws as a concept which leads to parental alienation. Now, the audience may have been introduced to this concept because these webinars are going on since yesterday, and this initiative is taken uh, advocated against by this particular NGO. By this particular organization, very nicely. The parental alienation, in short, is a situation where the custody of a child is granted to one parent, and then that one parent, of course, that parent had a dispute with the another parent, so the parent to whom the custody of the child is granted, that parent starts manipulating the mind of the child, starts instigating the child to be against the other parent. It might entail telling lies or levying false accusations to the other parent, or telling bad things about the moral character of that parent to the child, and it may also include telling the truth or creating false stories, narratives, which may make the child hate the other parent and distance itself from the parent. Now, in India or wherever we go, the custody is not the subject matter of a dispute. initially. The question of custody in law arises because of some other question. For example, you wouldn't find a couple who is happily married, just that they are working in different cities, going to court asking for custody of a child, because that is not something which law has still evolved. Rather, you will find only scenarios where either the parents are separating themselves from each other by judicial separation or divorce, or there are disputes wherein the custody of the child is one of the issues. In only in those cases you will find that the issue of custody of child arises. And the very obvious thing is that when there is a dispute who shall have the custody of the child, the courts are left with only three options: either to grant the custody of the child to the parent who is claiming the custody, or second option is refusing to grant the custody of the child to the claimant and instead returning the custody with the defendant to whom against the case was initiated. The third option is if the court thinks that due to this custody dispute or any other reason, both the parents singly are not sufficient to ensure the well being or the best interest of the child, the court may even grant the custody of the child to some third party, especially close relatives or grandparents. Now, when we enter into such a scenario, which on paper is just theory, just a legality for lawyers, is actually a very concerning, psychologically depressing, and a painful scenario for that entire family, not only the child. Because now, inevitably and necessarily, one person, or sometimes rarely both of the parents, are going to lose the custody of the child. And all the problems begin here. In law, they recognize two kinds of concepts theoretically. One is physical custody, other is legal custody. Now, when it comes to physical custody, it refers to having the physical custody of the child and taking small day-to-day decisions on his behalf. Now, when we say custody of the child, it is very assumed that a child only means in India a person who has not attained the age of 18. Until the age of 18, the law itself does recognize so many disabilities on the ability of the child to take decisions for himself in contracts or in other civil matters such as trust. So, therefore, to take all these decisions, or even the small decisions of day to day life, whether to buy which clothes, to play with which friends, to not to play with which friends, to when to sleep, what to eat, to take care of these day to day needs, we call it as a physical custody. The second concept is legal custody. Legal custody is kept on a little bit of higher pedestal. It does not include physical custody of the child, but it includes the ability to take key decisions of the key decisions in the life of the child. Now, key decisions would mean some decisions which are not for the present, but which are also going to affect the future. For example, which school to pursue education in, which medium to pursue education in, what specialization to do after, let's say, matriculation when the child is not major enough, or uh, several decisions like if there is a property in the name of the minor, in the name of the child, how to dispose. So, all the matters which law regards as very paramount, in that case, the decision making ability is called as the legal custody of the child. The one solution which everybody comes up with when they feel that granting the custody of one child in a way alienates the other parent from the life of the child forever, a stopper to this, the concept of legal custody is advocated. Now, in this concept, what happens, and thankfully, it's a device of the law not codified anywhere but carved by the judiciary through its own wisdom to ensure that the child is not kept out of the love and affection as well as the abilities and wisdom of both the parents. Now, this concept of legal custody works like this: that the court, while deciding the case, will grant the physical custody of the child to one of the parents based on the circumstances of that parent, the ability to provide him basic needs every day, etc. etc. At the same time, it will retain the legal custody of the child with both the parents, in which, in common parlance, we call as shared parenting. It is different from the visitation rights. The concept of shared parenting entails that whenever a major decision has to be taken about the child's life, whether it could be redeeming his succession properties, or whether it could be joining a school or pursuing education which may impact his long-term career, etc., etc., both the parents will have to come jointly on the table and take a mutual decision. This ensures that at least that other parent has some say in the life of the child and he is not fully alienated. The second concept to stop the parental alienation, which the law itself, through adjudication and judicial wisdom, has gotten into, uh, is the visitation rights. Now, visitation rights is a very tricky concept. The entire dispute of custody of child began when one parent did not want to see the other parent. That was the level of animosity between them. In such scenarios, the concept of visitation right comes very it comes not with much confidence. It comes up with a caution that hey, you are free to not to meet that other parent, but for the welfare of the child, you will have to take that child to that parent, or you will have to allow that parent to come to your home and to visit your child. Now this might sound like a very positive concept because the other parent is being allowed to visit the child, but at the same time, sometimes due to the security issues or due to the trust issues, the courts order supervised visitation rights. For example, the parent would only visit the child when the other parent to whom the custody is granted is around. This actually hinders the privacy, and rather than leading to de alienation, it might create an hostile environment for both of them and eventually lead to the firstly, keep making the visitation rights redundant, and secondly, affecting the child morally and psychologically against the visiting parent. Now, amidst all of this, when we say there are so many things, the law itself has evolved which deal with uh, which deal with the which not deal with which try to eradicate or mitigate the concept of parental alienation. These methods are not solely foolproof because even though the other partner or the other parent is granted visitation rights or legal custody of the child, the larger amount of time, the disproportionately high amount of time is spent by the child with the parent with whom the custody, the physical custody of the child is granted. This creates a potential playground or potential ground field for the parent to infiltrate the mind of the child against the parent if the custodial parent so wishes to do, and it may lead to, as we understand the concept of parental alienation, it may lead to the manipulation of the child to hate the parent to the extent of hating the parent. Now here I would like to highlight a case law and then I would rest my case. As I see, it's already past 8:30. The case law is it's a very ray of hope, and how I'm praising since my beginning that codification starts very late. The law first observes the society, allows full time the humans to settle their disputes or to settle their scores themselves. When it feels that it is needed, the law is made, but very often it falls short, and then the judiciary has to step in. Here is a case law. The case law is titled Vivek Singh versus Romani Singh, 2017 Supreme Court. In this was a very particular and peculiar case of parental alienation, and thanks to the judicial wisdom and judicial positive approach, they recognized the concept and provided an appropriate remedy. In this case, the mother was initially allotted the custody of the child. However, through expert evidence, the party proved that the mother was instigating the child against the parents. The mother was telling all the false narratives as well as labeling the character of the father as very bad person in the minds of the child, including telling the child that he has abused, etc., etc. And all of because of all this, when it was brought before the court recognized the effects of this, the how it is a social evil, and in that judgment, the judges came on very harsh on the concept, on the tactics, and on the social evil performed by the mother, and they took away the custody of the child from the mother and gave to the father. We require such approach by the judiciary. We cannot say that in every case or every acquisition of parental alienation, the judges directly should come harsh on the custodial parent, take away the custody and give it to the give it to the claimant or acquisitor. But rather, what I demand here is that the judiciary should have a flexible, open approach where just because the law does not provide for this ground to take away the custody, their hands should not be tied and their hands should be free to see the evil going on. And if they can see the evil going on, which is created or which is left open by the law in the society, their hands should be free to remedy it. Yeah, thank you.
Thank you, Sarvesh. It was very succinct and it was very uh, so elaborative. We we learned a lot, though it was very brief. Because you highlight very important key points. Before going to the question, before going to my questions, I would like to see ask the audience. Do you have any questions to Sarvesh?
Yeah, I have a question.
Yeah, please.
Sarvesh, this is Rahul Roy speaking. Thank you
Rahul,
for
where
the
are you from?
nice.
Please introduce yourself.
Yeah, I am from Delhi.
Okay.
So my question is, again, this is a very important and sensitive topic that Sarvesh spoke about. Now, when a case is raised to the judiciary for parental alienation acquisition, right? This is a very subjective and very behavioral use case, right? So, how does the judiciary even understand or know if the acquisition is true or false before they go towards a verdict?
All
How
right.
is it proved or how is it even vetted by the court?
All right. All right. That's a very logical question, but the answer lies in the Evidence Act and not in the child custody laws. So the Evidence Act provides scope for expert evidence, and expert can be anyone. So a child counselor can be an expert, a psychologist can be an expert, and when we talk about parental alienation, the concept lies in the mind. The concept will not be visible through any physical evidence. It's not that the child is being abused by the parent, it's that the mind is being polluted by the parent against the other parent. In such cases, the evidence could only be extracted by effective examination of the child, effective cross examination of the child by child counselors and psychologists. They both are recognized as expert evidence under the evidence law, which presently is the Bharatiya Sakshi Adhiniyam. So yeah, and judges should also be open. Judges should also be not biased towards any gender or not biased towards any particular phenomenon. Because when it comes to psychology, it is very essential that the judges do not assume anything, and judges remain open to all the possibilities. We may have seen this very particular fact in criminal law when defendant when the accused takes a defense of insanity or some psychological disease. Very often the defense is lost, not because the psychologist was incompetent, but because the judges were biased against such psychological disease. So yeah, the my answer to summarize: firstly, expert evidence will help, and secondly, expert evidence will not alone help if the judges are not open to all the possibilities.
Interesting. Thank you. Thank you so much.
Okay, then I'll be asking my question. Sarvesh, I have multiple questions. See, because why I'm asking this, I want to know few perspectives
All
because
right.
I'm in the field of fighting against parental alienation. First of all, it is very difficult to file a case as parental alienation, right? So in that case, how to file a case? How to make the lawyers, how to make the judge to accept the case filing? Please, first question.
Your question is how to convince the system,
How to
right?
convince or how to, are there any alternate terms in which we can file a case? Because once you term this as parental alienation, because you said we have to go for experience, it's a long process.
Yes.
Time is going to consume. shortest, quickest way where a parent can help themselves to visit the child immediately. What is the way? Without use, because they can fight for the case of parental alienation. Before going to that, what is the shortcut to approach the child? Is there any, please, any wisdom?
No, sir. So I'll be very honest here. Once the custody is granted by the court, there is no shortcut to it to remove, to change the custody. Once the custody is granted by court, you can only go to the court to review the custody on the grounds of that the custody is not ensuring the best interest of the child. Now, initially, best interest of the child was only looked at from material perspectives, like whether the child is getting good food, living in a good locality, going to a good school, learning a good language, and being roaming around with good people. But but when the international approach came in, when the human rights perspective came in, one of the essential points of best interest of the child also includes the right to love and affection of both the parent. Now, in parental alienation, what happens when one parent fills the mind of the child with hatred towards the another parent? In effect, that parent is depriving that child the love and affection of the other parent. So, this is the ground of best that the custodial parent is not ensuring the best interest of the child by denying the child the right to love and affection of the other parent. You can take this ground and go to the court and ask for custody of the child. This is the only method. There cannot be shortcut. There can be interim injunctions you can obtain in the same matter, stating that the threat of the parent is too much on the child. So please take away the custody of the child from that parent. The court may not give you the custody, but as an interim measure, the court may take away the custody of the child from that parent and give it to somebody else. Which again, we have studies to prove that often changes in the custody is also not good for the psychological and mental well-being of the child.
And this is when there's a custody being granted. I'm telling you when the divorce be initiated in the initial phases. Mostly because what there is a concept. I mean, what I've read from the child custody laws, father is a legal guardian, but this is least respected, right? So whether the child is less than 6 years or more than 6 years, it goes to the mother only, naturally.
All right, so I'll clear your
Yeah, please.
actually point here. So firstly, the Hindu law says that the first natural guardian of a child is the father. The same is the case in Muslim law, and the same is the case in secular law. However, in Hindu law, expressly it is recognized that when the child is below 5 years of age, the first custody, not the guardianship, will go to the mother. Now, here, when I use the terms custody and guardianship, actually the concepts of physical and legal custody come into play. Now, your concern is that even if the child is more than 5, the custody goes to the mother. So this is a usual case, no doubt. This is the frequent case, no doubt. But since the best interest of the child principles have evolved and they keep evolving case to case basis, if you have a good lawyer, you can prove that if the best interest of the child is to send him with the father, then you cannot be prevented from doing so.
Okay, this
So
is
it all
even during
depends
the.
on how you ensure the best interest of the child and how you convince the court that best interest of the child is in this and not in that.
Okay, it is about. It is all in the how skillful the lawyer is, right? Ultimately, to convince the judge.
Lawyers do it through other experts on the
Understood.
subjects. Yes.
Because usually what happens, lawyers they go with very direct approach. So many times when I speak to the affected parent, they said, "Sir, my lawyer said first you child file for judicial conjugal rights, then visitation. By the time goes by 9 months, 1 year goes by. So the child is being alienated. That is what.
Thank you, sir.
Yeah. So there's one more thing. What I want to understand from you.
Yes.
Uh, the visiting places could be so detrimental for the child inside the court. That's a concept of some shared spaces. Do you want to give any insights on that? How to navigate that for children's sake?
I didn't get it, sir.
There is a visiting space theory, inside courts
Yes.
certain space. It is so healthy for the child.
Yes.
So what's any other like any other alternative where a parent can choose for a supervised
Uh,
visitation?
it's more of a psychological social question where you can actually cite researchers to convince the court or to convince the lawmakers that this can be the atmosphere or this can be the particular surrounding or the environment where the child will feel comfortable and even the parent would feel comfortable. So places are it's not rigid, it's very flexible. Sometimes courts grant you the visitation rights to specific places.
Okay. So judiciary they'll accept the submission of research articles to prove this is
Yes.
harmful to the child. Okay.
Yes,
Yeah.
if they're convincing enough, there is a proper research to back it up.
Yeah. One last question to you, and let's next we'll go to Mr. Vedan. Why interim maintenance is such emergency, even though one parent is earning, but not the custody or visitation? Please.
Uh, I didn't get why the interim maintenance is so
Why
necessary
the
if
interim
even the
maintenance
parent is earning.
is decided on a very emergency basis, even though the other parent is earning, but the custody or the visitation is being delayed.
I think that's not a correct approach to look at the issue of child custody because interim maintenance and child custody both are a very different and independent concepts. I may see where you're coming from. Uh, the urgency is shown much in the maintenance cases and not in
Yeah,
the child custody cases.
yeah.
But I think that's not a correct approach to look at it. The solution would not lie in deprioritizing the maintenance issue because that may also be equally pressing depending on the case to case. The concern may lie on the effective well-being of the child. If in that case, if there is a person available who during the ongoing of the proceedings, which we call as lispendence, who during the lispendence can take care of the child, then of course you may convince the court to expedite the custody matter or the interim custody matter at least.
Thank you so much, Sarvesh. It's a pleasure
My pleasure.
listening to you. Yeah. So I don't see any questions, so we are moving to Mr. Vedant here. You can be online, and by the end of the time, if there's a common question, you can attend.
Yeah. Good
All
evening,
right.
sir. Yes.
Hi, Advocate Vedant. Your video is off. Please switch it off.
Just a minute, sir. I'll just. I hope I'm visible.
Yes, visible. Yes, visible.
Yes, sir.
So now we are having Advocate Vedant. Uh,
Sorry, sir.
I'm just giving you an, inter, an introduction. I'm introducing you.
Right, right. Yes, sir.
So before going to the formal introduction, so let me give a clear picture for the audience. So when he spoke about Gen Z and social information, he said one word which caught my mind so much. Uh, there was a person who made a reformation at the age of 21. So what we read in history, oh, this is a great old guy who's being reformed. But he's at one point. That guy was Gen Z for his time. Actually, true, very true. So that was very, very motivating and very inspiring for me to hear. So that is where I got attracted to his speech. And next, I listened to his enacting of Julius Caesar, Shakespeare's play. So those things. So coming to his actual introduction, he's an alumnus of Maharashtra National Law University. He's a state topper in multiple subjects. He's a recipient of the Principal Nirmal Das and Srimati Kamala Gurbakhshi Prize for advancing constitutional awareness and human rights. He is director of V Compass Juris Private Limited, executive coordinator at Yuvak Biradari Bharat, hope I'm pronouncing it right, and associate to Honorable Justice retired Sadhana Jadavji in arbitration. He has co-founded with Sarvesh the Bharatiya Samvidhanik Samaj and is a trained RT activist under the former CIC Mr. Shailesh Gandhi. He is a much sought after speaker and trained theatre actor under Padma Shri Professor Dr. Raman Kandre. Vedant is widely recognized as a dynamic legal educator and a social change maker. So it's a pleasure to invite Mr. Vedant, Advocate Vedant for our program, and we are here to hear a different perspective. This is about because first we saw what Sarvesh spoke, and here Vedant is going to speak about child independent lawyer limiting the damages of the parental alienation. Please take over.
Thank you very much, sir, for the introduction. Thank you very much. Uh, Also, thank you, Sarvesh, for setting the tone and also making my work easy on that matter. So, I'm here to talk on two concepts which are not codified yet, but there have been judgments by the courts, or there have been recommendations by the law commission, and also interpretations by the court on this matter. So, when Sarvesh talked about custody and other points, there are two important matters in this. First is the representation of the child himself, so or herself. A child cannot be, he cannot represent a child because a child is a minor. So, here there is a concept evolved called as child independent lawyer, CIL, or independent child lawyer. Of course, this child independent lawyer is not a lawyer of the child, quote unquote, uh, like working like a adversarial system of a court. The work of this child independent lawyer is to ensure that all the welfare of the child is taken care of. There is a difference between wishes of the child and the welfare of the child. So, basic welfare of the child is taken care of and represented in the court. This child independent lawyer also interviews the child, uh, does the examination, cross examination of the parents, witnesses, and also put forth the children's perspective. He's the child independent lawyer is not arguing, but representing in front of court. The case which my friend quoted on of Vivek, the landmark case where they pointed out on the concept of this shared parenting and the representation of the uh, child. Now, why this is important that child should be represented by some independent person? Uh, because the child, of course, is a minor. That's why it cannot take decisions on very consciously, of course. Um, that's why there should be a person who should uh, take care of the welfare of the child. So this is the first point. Second point is about concept of shared parenting. I'll make a very bold statement that at times, I'm using the word at times, children are the victim of marriage system. Uh, I know very personal cases also. Personal in the sense, I know some cases where the child is suffering because of some random issues or very trivial issues between the husband and wife, and the victim is child, of course. And it is said psychologically because being a student of psychology, uh, that the childhood trauma which you get and the violence if you see or anything negative which you see in your childhood uh, is of course not, there is no having effect in that present, but in future when you grow up as an adult you have that childhood trauma, and that's why your behavior becomes very aggressive. You often become very lazy, procrastinating. Of course, this is not a hard and fast rule, but psychologically speaking, medically speaking, this may be there. Now, that's why to ensure that the child is getting the love and affection of both the husband and wife, there is a concept evolved, something known as shared parenting. The Law Commission, in its 257th report, recommended that there should be a provision of shared parenting. So there's a difference between shared parenting and a split custody. Typically speaking, we know a concept called as split custody. Split custody means when the child is with the mother uh, and then father is having other siblings. So this is a split custody. I hope everyone is understanding this. Whereas shared parenting means that the parents come together for their child, for the welfare of the child, and make sure that all necessary things as a parents are fulfilled. Here, there is a difference between shared earning in marriage. Shared earning is different from shared parenting. Shared earning is where both the husband and wife decide together that they are going to have their earnings 50-50 for the welfare of the child. This is during the marriage, not after the divorce. So these are some concepts. Next thing is about something called as bird's nest custody. It's also very interesting concept where the child is at one place and the parents come there time and again. Both the parents, so the child gets the love of both the parents. Uh, Even though a very good concept in itself, this concept has been criticized that uh, typically scientifically you need a bond of only one person. This is what the criticism is for this shared parenting. But the courts have always been in favor of this particular concept of shared parenting. Of course, there is no codified law on this aspect, but there is a section 17 which talks about the welfare of the child, and that has been interpreted by the court. Of course, the 257th Law Commission report very vehemently highlights about the same. As I said, the section 17 talks about the best interest. So this best interest principle has been used to ensure that the child is having the best interest and getting the love of both the parents. I'm talking about section 17 of Guardians and Wards Act. Furthermore, talking, the Delhi High Court in the Vikram Bora versus Shalini Bhalla in 2022 pushed for shared parenting plans. Now, there is the concept is equal shared parenting responsibility. Uh, this is what is the concept. Now, talking further, in one of the case of Supreme Court, ABC versus the state, anonymous, it directed the family courts to mandatorily explore shared parenting before awarding sole custody. Again, this becomes a very important decision that before giving a sole custody to the to one parent, the court should explore first the concept of shared parenting and whether it is possible or not. Then, under the Family Courts Act, mediation must draft parenting plan. So here, mediation has been made very compulsory. These are some points where the welfare of the child is taken into consideration. Now, um talking about the child independent lawyer, which initially I gave a bird's eye view on that. This is also a very interesting and new concept. Again, as I said, this is not codified but interpreted. So, this child independent lawyer interviews the child, uh, cross examines the parents, the witnesses, recommends the custody, also gives the plans, Okay, but he is not the children's direct lawyer. He focuses on the welfare, not the wishes, as I earlier said. Then, usually, parent funded or court ordered uh, these decisions in the parents' pay. Now, there is no statutory mandate. Unlike Australia, in Australia, a child independent lawyer is a mandate. But as I said, the Delhi High Court, Bombay High Court, Karnataka High Court has appointed amicus curiae or child counsel in the custody battles. Now, what is an amicus curiae? Amicus curiae is the friend of a court. This is a legal terminology where the judge invites the senior most or the senior person to assist the court in the judgment decision. So this is called as amicus curiae. Um, or there is a child counsel appointed by the court. So of course, not the same word has been used, but the intention remains the same that the welfare of the child should be taken care of and to ensure that the child is getting adequate representation. So these were the two brief concepts which I wanted to touch upon, which are very important. Again, I give that a statement that the children at times are the victim of the marriage system, and I particularly stand by this statement because I have seen uh, families breaking down, not officially taking the divorce also, and then taking away the small child just because that child is 1 year, 2 year, 3 years, and not understanding anything, and taking away that person from father or mother, vice versa. This incidences have a lot of future impact on that child. These things need to be considered by the law, which are duly being considered. And this concept is a very important concept to be taken into consideration. Um, I would like to have more question answers. This is just a brief overview which I have given to everyone.
Yeah,
Yes, sir.
hi, Advocate Vedan. Very nice way of put forward, and it is very you have explained about this amicus curiae. It was quite new for us, and of course, it will be new for us only. And you touched upon
Correct.
equal parenting, shared parenting, all
Shared
definitions. So,
parenting.
yeah, because split parenting. So this is where people want people. First of all, the parent has to get knowledgeable on these things. Then only they'll be
Correct.
able to think for themselves and how they can present the case to the advocate and aid the advocate in arguing in favor of them with the best interest of the child.
Correct.
So again, as usual, I want to leave the space open for the audience to ask the questions. Okay, I'll ask them. Okay, this is a concept in India. Vedant, your videos is frozen. You are there?
Ah,
Rahul, you have a question, right? Mr. Rahul?
no, I asked my question to Sarvesh already.
Okay. I think he has got some network issues. He may be joining again.
Hmm.
Please wait. Hi, Vedant. Yeah, welcome back. Vedant, you there? Hello, Vedant. Vedant, I think there is some issue. Your mic is not on. Okay, we'll wait anyway.
Hello, sir. Am I audible now?
Yes, Vedant, you're audible now. Yes.
Sorry, I think there was some meeting. I was
Yes.
just
Yeah, you can
I'll
keep the
able
video
to leave
off.
the meeting. I don't know how.
You can keep the video off.
Yeah, no. I'll keep my video on also. I'm the internet is stable now.
Okay, fine. So my
I
question,
was awaiting for sir questions. Were there any questions?
yes, yes. See, this is a conceptual thing. This is given by the Center for the Advanced Legal Research, right? The CIL in India. This is still in the conceptual stage. Can this be recommended in the court now? Will there be any
Yes,
weightage given?
in fact, as I said, I told that the concept of shared parenting has been recommended by the Law Commission itself in the 257th report. So it can be very well implemented. In fact, it has started to be implemented. It is just that it is not codified. That's the only one point. There is no statutory law, but the custom, the practice has started. As I mentioned, the courts have also started exploring before giving a sole custody. They have started getting an option of shared parenting.
But we can't state as CIL. That
Sorry?
is, we can't ask that to appoint a child independent lawyer for the child. We can't request it
Definitely,
as
as I said, that amicus curiae is there, or the child custody lawyer, or child independent lawyer. The names may differ, but the intention remains the same, that the child should get the uh, welfare of the child should be considered um, over everything, and the child should be represented. Of course, again, I say that this lawyer is not going to represent legally. I mean, he will not be fighting on behalf of the child, but he will ensure that maximum welfare is being having for this child.
so we can say that please grant the amicus curiae for this case.
Independent lawyer, amicus curiae. I think these can be some words which can be
But
used.
this can't be used in a family court, right? This can be used only in the high
Sorry.
court or family courts at the lower level. They won't be able to acknowledge this concept, right?
They will be able to, yes.
You mean to say that even in tier 2 and 3 cities, is it possible?
I think that will take time, but particularly speaking for cities, this has started.
Okay, cities started. Okay, and you said the welfare of the child. How will the court ascertain the welfare of the child, or how can a parent prove that this is the welfare of the child?
How can?
How can someone ascertain? How can someone prove that this is the best interest for the child, or this is the welfare of the child? How can we prove that?
I think when it comes to the concept of welfare, it comes to the point of basic necessities of the child is being considered, and also making sure that the mental well-being of the child is considered, and the basic things required for the child to grow in his tender age, as I mentioned about the psychological concept of childhood traumas. So these things are avoided. So these are some basic parameters. Of course, there is no such hard and fast rule to calculate a welfare, but a basic reasonable human, whatever considers to be a welfare, that can be considered. Again, I mentioned it is not for wishes of the child, it is for the welfare of the child.
Hmm. So, is there any case recently where you have seen where people started to use this CIL concept?
There have been many cases, sir, particularly in the high courts, as I mentioned in my address also. The high courts have started uh, doing this. The names are differing. They are using the words like amicus curiae or child custody lawyer or something like that. But again, the intention is the same.
Yeah, one more thing, one last thing maybe. Is there any way where an NGO, somebody which has a lot of research evidences, where they can offer trainings to the a family court? Because many times I'm seeing that family court needs education, some training and all. Who's going to give them? How will they accept it? How to present it to them? Any tips on that?
You're asking for NGO who can train the lawyers for to become a child independent lawyer.
No, no, no. NGOs, for example, a family court requires a specific training to handle these cases, right?
Correct.
Yeah, how to educate them, how to train, who will train them, who will educate them? Can NGO come
No,
forward to do
actually,
that
we
voluntarily?
don't require a specific training for family court. A basic law degree is sufficient to practice anywhere. Of course, there are courses and all which are given. So when it comes to family court, it is said that the approach to the case needs to be very different from the civil and criminal because the matter is very sensitive. Your approach should be very sensitive. These are some things which are said in the practice, but there is no such course or training program.
No, why? Because see, some concepts, if somebody presents in a high court, the judge will accept or understand. Whereas what I heard, no, the lawyer say that the judge won't even take the case. The case won't be
Well,
numbered.
sir,
I mean, I'm telling you about type 2 since it is. If at all we present a case of CIL or parental alienation, the judge will not allow even to register the case numbering, I mean.
right, I get your concern about tier two cities, but here then the concerned person can go to high court if the lower courts are
Not
not
taking the case.
giving them the relief.
No, no, I mean to say that if the lower court is not taking the case, can the person directly go to the high court?
Yes.
But the judge will not reject on paper, no? He will reject only orally.
Could you repeat your question, sir?
See, there is a case, for example, one parents want to file a case as a parental alienation. But judge says that no, I can't number the case. I can't give the any approval for numbering the case.
The judge says that.
This case can't be taken under this clause.
Okay.
Then can the parent go directly to the high court?
Of
But
course,
only
sir.
no,
Any
but only
citizen of this country
but
can directly go to the high court.
judge has rejected only orally. No records that he has rejected.
No, uh, in this case also, high court is very much possible. The doors of the High Court and Supreme Court are always open for all the citizens of this country.
No, but we have to go through the same lower court, middle court, then
Of
the
course,
next court.
that is the mandate. But then, if there is an extravagant situation, emergency situation, uh, or maybe the fundamental rights of a particular person, maybe the child itself are getting violated, or maybe if there is a loss in the petitioner or the respondent saying that we want to go to the higher court now, they can go, sir, very well.
Without
Appeal is
applying to
very much
the
possible.
no, without applying
And
to the
rather,
family
I
court.
would say they can directly approach the High Court also under Article 226.
But will won't High Court reject that? Why didn't like like why are you coming and wasting your time? Why don't you go to the family court first, then see what they're saying, then come back to us.
Could you come again, sir?
No, when the High Court say that, why are you wasting your time? First, you go to the family court, then come back
Usually,
to us.
this is the matter which they do.
Hmm.
That first exhaust your remedy. This is a word, exhausting the alternative remedies with you, and
Hmm.
then you come to the highest authority. This is what it is said. But there are various Supreme Court judgments which say that this is not a hard and fast rule. Nowhere in the Constitution it is written that first you need to go to the lower court, then the High Court, then the Supreme Court. It is a appeal mechanism which is being made.
If the judge is to understanding the case being filed, so the petitioner can go to the higher court.
Could you come again?
If the judge is not able to comprehend about the case being filed, or
Yeah.
he's rejecting that I won't take this case, then can the petitioner go to the high court directly?
I mean, this will judge will judge if the judge rejects the case. This will happen on merits, on some points of law or points of facts. It cannot be it cannot happen just on the will of the judge. And of course, if the case is rejected, then they can go to the High Court.
Hmm. But it is all about how best they are going to choose a lawyer, how best they're going to argue. Understood that. Understood that.
Of course. So it is said that some of the very great lawyers like Nani Palkhiwala, once he was arguing in the Supreme Court, arguing the landmark case of Keshavananda Bharati versus the state of Kerala. Against him, the gigantic lawyer, advocate H.M. Sirvai was there. And the arguments went on for a while. And the judges said that I am not convinced uh, with with Nani Palkhiwala's argument. So Nani Palkhiwala said no. Uh, so judges said, are you saying that the courts are not able to understand? Nani Palkhiwala was arguing. The the court said this is not the case. Then he contradicted. He said no, this is the case. Then the Supreme Court said, are you saying that the Supreme Court is not understanding, or we are wrong? Nani Palkhiwala very beautifully said that, Your Lordship, I am not able to convince my argument. I think I just brought this incident because you mentioned about a good lawyer.
Hmm.
So it is about how the advocate is able to convince the judge his or her case. I think everything boils down to that.
Understood. Understood. Makes sense. And one last question before you close. You mentioned about the case of Romani scheme. How did the case happen in the Supreme Court? How did they accept the concept of parental alienation?
Could you come again?
The case of Romani Singh, how did the Supreme Court accept the concept of parental alienation?
You mean Vivek Singh?
Yeah, sorry, Vivek Singh, sir. Vivek Singh. Vivek Singh which is Romani, right? 2021.
Um, yes. So,
Yeah.
how did the court? What is your? I'm not. Sorry, come again,
Because
sir.
this is the first case where the court accepted parental alienation. So how did it happen? Any insights on that? Insights.
So the court particularly focused on the welfare aspect, as I said, uh, of the
No.
child
What was the
in this
evidence
case.
given by the parent? Which evidence was there? What evidence was given for alienation?
I will actually have to go deeper into the case to understand the evidences, sir. Uh,
Understood
I
with
think
that.
Mr. Sarvesh can shed some light, but
He's not
uh,
there. He's not there. I asked.
I
We
don't
asked.
see Mr. Sarvesh here.
He said he has some work. He has to leave.
Oh, okay, okay.
So good. See, though we have crossed 1 hour, I'm going to close the session. Because you spoke very beautifully on CAL and what is the concept and how we can approach the case also. And this
Yes.
session has been live streamed on YouTube. It is available. People will definitely go back and see that. And I'm pretty confident that this will help the affected parent because they will make them think what are the options for them to approach the court and to discuss with the lawyer. So once again, thank you, Advocate Veda, for spending time with us.
Thank you,
And
sir.
yeah, we look forward for the next session with you, future. Yeah. So thank you, everyone.
Thank you, everyone. Thanks for
Yeah.
that.
Definitely, sir.
Thank you. Thank you.
Look for
Right.